Hi guys, welcome back to my YouTube channel. Thank you so much those who have subscribed. Those who are yet to subscribe, please subscribe. This is an educative channel. You're going to learn more content is coming. Please tell a friend to tell a friend to tell a friend to tell a friend to share, to like, to subscribe, and to comment down below on the issues you want to appear on this channel. We are going to talk about an interesting topic on succession. There are two types of succession, or rather two types of grant. Testate succession is also called, or rather referred to as, a grant of probate. Intestate succession called a grant of letters of administration. So I will simplify the two types of succession. Where a person dies, leaving a will, rather putting his affairs in order, how his property will be managed, his debts will be paid if he had debts, if people are owing him, how his money will be collected. Then that person puts down, or rather writes down, a will. Then such a succession is called testate succession, or a grant of probate, where a person dies leaving a will behind and appointing an executor. It's called testate succession, or a grant of probate. So in this situation, an executor who has been appointed, or rather an executrix, it's a female, executor is a male, who has been appointed in this situation, will have to apply for a grant of probate at the court's registry to give him or her powers to manage the affairs of the deceased persons accordingly, or according to the will. It's only until the executor has applied for a grant of probate in court that will enable him or her to have the powers to execute, or rather to manage, the affairs of the deceased, or rather the properties. But please note that the executor or executrix can at any time relinquish his or her power or decline to manage the properties of the deceased, but he or she should not have intermeddled with or misused the deceased property. So in such a situation, then the deceased died knowing, this my property, I have given to this. So the person who is in charge as the executor will make sure that the transition is smoothly. And the second type of succession is called intestate succession. Intestate succession, or a grant of letters of administration. So in this type of succession occurs whereby a person dies. Maybe he or she had a road accident and then they died instantly. They didn't anticipate that death, so they died without leaving a will. In such a situation, then any person can apply to court can petition actually to court for grant of letters of administration. But please note, there is a catch. Priority is given in order of consanguinity. By that I mean a wife, a husband, children, or parents of the deceased person. So before any person can just run to court to apply for grant of letters of administration, priority will be given. The spouse is still alive, the children are still alive, the parents are still alive, then the uncles, the aunts can apply for the grant, or rather can petition to court to apply for grant of letters of administration. So in this case, the person who will be in charge, let's say the deceased person was a husband, then a person in this case who is entitled to apply to petition to court for letters of administration is the wife. If the wife is still alive, then the wife will petition to court to get the grants of letters of administration that will give her the power to administer the property, or rather manage the property of the deceased person. So in the earlier type of succession, the testate one, the person who is in charge is called an executor. But in this case, the person who is in charge of the deceased person is called an administrator. Hope you get the difference. But either way, they play the same role, they do the same job. The only difference is the manner in which they move to court, under which circumstances, attested succession or intestate succession. So please get the difference, but they just do the same role. And in the earlier attested succession, the difference is the testator himself, the person, the maker of the will, is the one who appoints an executor or executrix of his choice or her choice. But now in this other type of succession, the intestate one, whereby the deceased dies without leaving a will, then the petitioner, yes, who is the administrator, is the wife, if the wife is still alive. But in that order of consanguinity, the wife, the husband, the children, the parents, then the rest can follow. Please note that both the executor and the administrator are not supposed to intermeddle with the deceased, with the properties of the deceased. They are not supposed to rather dispose of, sell in a manner which the deceased will not have preferred. They're supposed to manage the deceased property accordingly. Then the question will come, who is a dependent? A dependent is a person who was being maintained by the deceased prior or immediately before his death. This may include a wife, children, grandchildren, brothers, sisters, aunties, uncles, stepsisters, stepbrothers, stepuncles. So any person who was being maintained by the deceased immediately prior to his death, then that person qualifies to be called a dependent of the deceased person, or rather is entitled to inherit from the deceased. Please note that a surviving spouse is entitled to personal and household effects of the deceased absolutely. The life interest, the whole of the residue of the net intestate estate. Life interest operates as a safeguard for the children in cases where a surviving spouse is likely to waste that property. Surviving spouse enjoys property in their lifetime, hold the same in trust for their children. In a case where the intestate estate has left only a surviving spouse and no children, then the surviving spouse is entitled out of the net intestate estate. In a case where the intestate has left no surviving spouse but with surviving children, then the estate devolves upon the children, who should share the estate equally. Instance where there is no surviving spouse, no surviving children, then the estate shall devolve upon the kindred of the deceased in the following order: mother, father, brother or sister or their children, half brothers or half sisters or their children, relatives who are the nearest consanguinity. If the above mentioned will not be available, then the deceased estate shall be liquidated in the consolidated fund. In a case where the deceased person was polygamous, then the personal effects, the household effect, and the residue of the net intestate shall be divided among the households according to the number of children in each house. Net intestate estate devolving upon children shall be held in trust on behalf of the children until they reach the age of 18 years old. Please note that every person is entitled to inherit from the deceased person, be it girls or boys, male or female, married or unmarried. No one should be discriminated at any given time when it comes to inheriting the deceased property. All the children are entitled to inherit their deceased, who are their parents or close relative, properties without any form of discrimination. Please, please, please note that. Marriage is not a factor in determining a child's rights to inherit his father's property. Please note that it's a criminal offense to intermeddle with the property of the deceased person without an authorization of the court. Intermeddling is simply interfering with the deceased property, or rather the estate of the deceased person, without proper authorization. It's a criminal offense and it's punishable in the court of law. Thank you so much for watching. Bye.